welcome to the latest in the Greater China Legal History seminar series from CUHK Law. My name's Stephen Gallagher. I'm very pleased to introduce our speaker today. Before I do so, let me just say that we'd like to welcome you all here. We'd like to encourage you, of course, to ask questions of our speaker. If you do want to ask any questions, please use the chat function and you can chat those questions in to me or to my colleague Jay, and we will ask at the end of the talk. Hopefully, if we've got a few minutes left at the end, we'll ask Professor Tam your questions as well. So let me introduce our speaker. Professor Tam Kar-Chai has, of course, strong links with CUHK. He is an alumnus of CUHK. Before he went off to study at Oxford, he studied at CUHK and received his BA in history and MPhil as well from CUHK. So strong links. Also, we should say that Professor Tam has a distinguished history in teaching as well. He's taught at the Hong Kong Polytechnic University and again at CUHK, and presently is teaching in the Department of History at the Hong Kong Baptist University. Professor Tam has numerous publications, but I should just mention a couple of his most recent books on Chinese legal history. These include Justice in Print, Discovering Prefectural Judges and Their Judicial Consistency in the Late Ming Period, and The Spread and Restrictions of Catholicism Under the Judicial Perspective in Ming and Qing China as well. But again, numerous other publications. Professor Tam spoke for us before in the Greater China Legal History seminar series. His last topic was, it seems, quite a long way from the present topic. It does involve the Ming, but last time, of course, Professor Tam spoke to us about controversies on the morality and effectiveness of judicial torture in the Ming China. Well, today, his title is still an intriguing title, Crying for Justice, the Impact of Public Opinion on the Local Judiciary During the Ming Period. So an interesting concept. I didn't really know there was much public opinion influence on judicial decisions at that point. So let me pass over to Professor Tam to explain to you about his talk today. Professor Tam.
Yeah, thank you very much, Stephen, for letting me to share my opinions and also my findings in the Chinese legal history, particularly during the Ming period. But you may realize that during my presentation, the period, or maybe the temporal sense, is not limited only to the Ming, but from the Tang down to the Qing, some related issues would be shared with you about how the public, particularly their opinions, or maybe the ways that they express their sentiments to the court, and how did such actions may influence the decision of the judge. Now, before really going on, let me share with you the PowerPoint today. Yes. Yeah. It's here. So I think most of you are having lunch now, right? I promised Stephen and Lucy that I won't talk about anything gruesome to influence your appetite. Today, the topic is Crying for Justice, the Impact of Public Opinion on the Local Judiciary During the Ming. So, in the very beginning of the talk, let me just introduce you with something quite interesting about novels, about the literature on Chinese culture. But I'm not talking about a Chinese author. Instead, I'm going to give you some introduction and some sense of the contribution of a Dutch sinologist, Robert van Hulik. This gentleman, this sinologist, is quite interesting in the field of sexual and also legal life of traditional China. Yeah, I think most of you, if you are having experience of Chinese culture in the last few decades, you may have learned about a book called Sexual Life in Asian China. It's his contribution to the field and very influential, and many Chinese scholars, I mean native Chinese scholars, follow his footpath and study this taboo field under his enlightening guidances. But well, this is not the only major contribution of Wang Hulik. His more influential way to impose his fame to the world is the detective novel series, Judge D Mystery, whose hero, Judge D Renjie, is quite an historical figure. Sometimes if you are studying Chinese history in Hong Kong, Di Renjie is known as a major minister during the rule of Wu Zetian, the only female emperor, the empress in Chinese history. So, but before being the minister of the state, he served as a magistrate in the locality. So the wise Chinese magistrate from the Tang Dynasty, Di Renjie, is the hero of Wang Huli's novel series. And this novel series provides us the excitement of Di Renjie's solving of many complicated criminal cases by his bravery and also supreme intellectual capacity. But the merit or maybe the importance of the novel is not only the protagonist of the stories, but also the legal system in which Judge D played a part. So the contribution of Wang Huni is not introducing us a very famous judge, very smart official of traditional China, but give us some concrete sense to the Chinese legal system. So in the postscript of the Chinese maid's murder, Wang Huni faces the merits of the traditional Chinese judiciary, almost against all odds at the time, to the general bad opinions, to the backwardness of the law of the Middle Kingdom. He composed his novels during the 1960s and 70s, and at that time and before that, for more than a century, the Chinese legal system were considered quite backward, quite bad in modern sense. But well, instead, Wang Huni gave us the following comments. All in the old Chinese system worked reasonably well. Sharp control by higher authorities prevented excesses, and public opinion acted as another group on wicked or responsible magistrates. So it's also my findings in my last book on the local judiciary of the Ming Dynasty. I find that the mutual tracking of officials in the provincial level is quite impressive. Like a certain case may go through 8 officials in maybe 11 rounds of hearings. So it is quite a careful system. And indeed, if you can revisit the code here I'm discussing, so you may know that also the impact of the public opinion to the court are seen in some ways that Wang Huli continued his description of the merits of the system, that the magistrate was not allowed to interrogate any accused or witness in private, and all the hearings of a case, including the preliminary examination, had to be conducted in the public section of the tribunal. And the keyword of the Chinese proceeding is therefore openness. More importantly, after the procedures, the magistrates or the judges of all levels needed to keep record of all their proceedings, and the case reports had to be posted in front of the court, as well as forwarded to the higher authorities for inspection. So this is the functioning of the system, that the credibility of the judge or their judgments should be publicized to the whole world to know, including the superior and also the commoners in the jurisdiction. In the late Ming case book, Meng Shui Zai Chuan Du, which is one of the key of today's discussion, its author Yan Zhenyan, he would be the hero today instead of Judge Yan. I will mention his name many times afterwards. The prefectural judge of Canton from 16 28 to 1636, announces the following practice of public pronouncement of his court decisions. So it is his own words. Let's see what the layman judge disclosed about the openness of his court. So when the facts are clarified, the judge must publicize the case report for public inspection. In my court, this will be announced within 3 days, and further detention of those documents is not allowed. The report is publicized for the whole country to know the judicial decision, so that no one can hide it and extort money from the two litigating parties. So it is one of the aspects of openness of the court. So the report should be publicized in front of the gate of the Yamen. Okay. This enlightened judge emphasized that he dare not postponing a moment to delay the follow-up actions of the commoners. What sort of things should be done by the commoners after learning the decision, after reading the report? And one of the possible actions that they may obey the decision, or if they are discontent about it, and they could do two possible things. The first is to launch the campaign to the upper level of judgment or of court, or they can, if they are illiterate, or if they cannot have better means to do the fast action, they can hit the drum of appeal in a upper level courts. Even maybe in the very early period of the Ming, they can even go to the palace to hit the drum. But it is not highly recommended in the later periods because the consequence could be quite lethal. Anyway, the follow-up actions is up to the commoners, but the main point here is that the judge should keep his decisions open for the checking of the public. So incidentally, although many Western travelers came to China and witnessed the brutality of the Chinese court, particularly during the late Qing period and early Republican period, and they compare against modern standard, and find that the Chinese court is quite backward because they witnessed many barbarous actions in the hearings. But the big question here is that what on earth the Qing officials would allow them to see all those barbarous procedures? This is a problem. If the court was not open, then the Western travelers would have no chance to witness those procedures at all. So truly, it was because the traditional Chinese government, at least reflected in the main cases, had always insisted that the openness of the court is important, so as to allow the people supervising the legal procedures, and thus prohibiting the frontline judges to overwhelm the law without consequences. So, well, in historical experience, we know that some judges may abuse the system, but they should face some consequence afterwards. So it is maybe the design of the system. So in this talk, we shall employ the materials found in the main case books to see how the layman judges, such as Yan Junyan, manage the influences of public opinions in their judicial judgments, especially when there were contradictions among principles of the law, witnesses and evidence, and the perceptions of the people. So how they manage those contradictions is one of the maybe the main point I would like to discuss today. So let's come to some examples, or maybe the own words of Yan Junyan on how he handled campaign about justice. So we may see the intervention of the people observing court procedures during the hearing. And as mentioned, the local Ming court is opened. No matter it is the confrontation of the accuser and the accused, the torture, the judicial torture I mentioned last time in this series, the torture to the culprit, or even the punishment to the condemned, all are allowed to observe the procedures on the spot so as to guarantee the credibility of the judge. So everything is transparent, well, at least on the surface, for the people to witness. So it is true that there were some general instructions for the observers at court. Like if you watch the soap opera on Asian Chinese court, you may see a tablet there depicting Su Jing, keep silent. Yeah, so it is one of the requirements of the court to the public witnessing the procedure. For example, so they need to keep silence, and also they need to, you know, do something like kneel down before speaking. Okay, but in case that family members of the two sides could not stand for the 40 facts or accusation, so they found that the description of the you know, the statement is problematic, then they may quite allow to complain about injustice in the due course. So though they may with some beatings for the violation of the etiquette of the court, the Great Ming Code indeed has no specific provisions to prohibit such actions, and the judges normally would not forcefully suppress this type of protests. Why? Because they didn't want to have the accusation to himself of inclination to one side or being excessively violent to the litigants. You know, the bad fame of tyrant of the court may affect their chance of promotion. So that's why the judges would not be too brutally, you know, punishing the public who cry out for injustice, or maybe they demand for some clarification of the situation. So the above is the theoretical situation, but how did it really work at court? The impact of public opinions towards litigations can be seen in a case, the boundary case of Li Chuanxiao and others. Okay, Judge Yan Zhenyan petitions in his judicial review that the last official who handled this case had disregarded the public opinion, in his own words, the Gonglun, the public opinion, and concluded it in hasty. So the criticisms of Yan Zhenyan is quoted as the following: when the intendant of coastal defense, so the rank of coastal defense intendant is a little bit higher than the prefectural judge, so he's a superior official, heard the case, he only mentioned that there should have a place where the robbery took place, and the spoils should have been divided by the accused. But these are all lacking crucial evidence, and thus his sentence was groundless. This is already rejected by the public opinion. So as the proceedings are open to all, it is natural that the observers could have their own opinions on the process or conclusion. As long as the judge pays no attention to them, the opinion of the people is irrelevant to the court proceedings, right? The main issue here, however, is that the judge must pay sufficient attention to the Gonglun, to the public opinion, or the verdict of the masses. And the opinion of the public towards his judgment may serve as an indicator to the quality of his judicial performance. So this is something, in the judge's own words, that the public opinions count. So in Yan Zhenyan's famous case of solving injustice, boundary case of Wang Yashi, Fu Youchong et al., the details about the ways that the observing public could intervene the proceedings are well depicted. Well, the details of the case is, let me summarize very briefly here. The coastal patrol of Guangdong in the Laming period were accustomed to the malpractice to arrest commoners by falsely accusing them as pirates, so that they could meet the quota requirement to suppress banditry at sea. So it's easy. This sort of corruption happened everywhere, particularly in traditional China. So during the Ming time, there's no exception. That the problem had forced the relatives and neighbors of the innocent, the falsely accused people arrested by the police, by the patrols, together at the court to complain about the injustice of their loved ones. In his case report, Judge Yan Zhenyan tells us his observations regarding such situations as follows, quote, I have investigated and find that in deciding a law case, if the judicial official reduces or increases punishments without comprehensive and careful consideration and sees the life and death of human beings as a trifling matter, his descendants should be initiated, and no living being will be left in his family. There is no other office more sorrowful and fearful than this one. When I saw the case of Wang Yaxi, it further enhanced my fear so that I could not stop the trembling of my muscles and thighs. So what Yan Zhenyan mentions here that it's quite religious for the judges to, perform well, or else the heavens would punish him and his family. So he must be very, very cautious about his duties. But anyway, it's something mentioned by himself, believe or not, it is up to us, right? He sees this trance, mentioning the heaven and maybe the karma, possible karma to the malpractice or maybe the misjudgment of himself. He continues, he sees this trance to campaign the unlawful prosecutions by the sea patrols. So he continues, the duty of police officers, such as patrollers, is to investigate and arrest criminals. Thus, it is suitable for them to arrest people who seem like thieves, just like the hawks and eagles catching birds. Moreover, as my superior, the he is mentioning another official who is supervising himself. The regional inspector treasured human life as of the utmost importance. He did not immediately order the killing of the accused, but hand them over to his subordinate, that is, the engineer himself. Thus, it is then the responsibility of the entrusted official, such as me, to investigate and try the case with precision and distinguish the accused one by one. The 29 people, including Wang Yaxi in this case, are the ones accused by the patrollers of dominating the sea and who were caught after a fierce marine. So if it really happened, there's something quite bloody in the due course of arrest. So if the accusations are authentic, it would greatly benefit the locality to eliminate the arch criminals, right? Well, if somebody who's really hurting the community, then the people should be happy about this, about their arrest. And the locality should be glad about in a gesture as follows, which is depicted by the Yan Zhenyan. The people should celebrate by putting their hands to their foreheads, where they would be very, very, supportive to the decision and also to the arrest. But when hearing the case, absolutely no atmosphere of celebration could be seen from the observers. Instead, Yan Zhenyan witnessed the melancholic people shouting out their complaints of injustice. He says, however, on the day of inauguration, over 100 elders of the locality campaigned together of injustice, and their voices shook the earth and the heavens. This stunned me, and I could not utter a single word from my mouth, nor write a single character with my brush. This is perhaps one of the explanations for the late publication of his report. But well, it's something that the sorrows, the sadness should be real anyway. So of course, our judge is seasoned enough. He's not that naive by just hearing the complaints of the people and change his mind. So he's seasoned enough to understand the possibility of buying witnesses by Bidbury. But he was overwhelmed by the big crowd gathered in unison to demand justice, so that he must reconsider if any elements of injustice were really involved in his case. Okay, the psychological reaction of the judge is explained by himself. We should also bear in mind that the court is sometimes located very far away from the villages of the periphery of the county. For example, taking Hong Kong as an example, is if a case is heard in the county court, like in pre-colonial Hong Kong, for example, if it happens somewhere here, or maybe if we are resident of Sha Tin, then we need to go to where? We need to go to Shenzhen, somewhere in the circle, somewhere maybe over 25 kilometers away. So you need to go that far to attend to attend the court proceedings. So it is quite far away. It took a big fortune for the transportation costs of a big crowd of over 100 people to travel to the Yamen. So yeah, that's why the judge was quite amazed about the gathering of such a big crowd of people to his court from the locality, from the villages. Yan further elaborates his hesitation. It is not impossible, the quote here, it is not impossible for guarantee to be secured by Bidbury in Guangdong. But how can Bryce make over 100 people come together as one and demand to take the place of the criminals? And how can the judge handle this by turning a deaf ear to them? Yan Junyan's struggle here reveals that in the meantime, it was unlikely that the judge would change his mind merely by learning the disagreements of the observers, because people with ample resources could possibly mobilize their neighborhood to impose pressure on the court to their advantage. Judge Yan, however, was hesitant to accept the facts provided by the report of the primary court and also the sea patrols because of the sheer number of complaining observers and their witnesses, the willingness to be the substitutes for the accused. So they want to replace the criminal, the arrested, and to be tried by the court. So that's what happened. Why they are so brave to take the place of the accused, because they are facing death penalty if they are really pirates. So it was difficult for Yan, the judge, who is withholding the legal principles while also referring to human feelings. He's explained by himself how he need to be obeying the Fali and also having reference to the 人情, the human beings, not to listen to these petitioners. He had no choice, the Yan Junyan had no choice but to revisit the details of the case. He soon found some reasonable doubts about the key facts of the case. Therefore, after carefully listening to the testimonies of the laborers, he decided to release some of the accused or reduce the penalties imposed on them, as many observers agree to be the guarantors of the true identity of the innocents. So the problem here is not the crimes committed by the accused, but whether or not the accused are the criminals being finger-pointed by the patrols, because they may be the wrong person, not the robbers. That's the problem here. And the people coming to the court to identify that they are not the accused robbers, instead they're innocent people. They're just commoners, wrongly arrested or maybe intentionally arrested falsely by the patrols. So for example, a certain Lao Jingshuan was mistakenly captured by the patrol as a bandit when he was actually selling sweets on the coast. So he's a merchant. His case of illegal capture was already lodged with the magistrate of his native county, and his community head He Zhachuan and others defended his innocence by swearing that they would take his place, and He's written guarantee is ready to be checked. And Yan Zhenyan then released this wheat merchant under the hints of loose neighborhood. So we may see here that the problem of naming Guangdong was not the distrust of the observers to the proceedings, but instead the patrol's laxity to catching wind and shadow in their vessels. Under the disturbance of bad policing, if the judge did not weigh the anger of the people carefully, it may cause serious consequence to the governance of the locality, because, well, not the bandits, but the innocent people were arrested and also killed by the law. Then how could the people be pacified at the end? So that's something the judge need to be very, very careful about. And in his report, Judge Yan Zhenyan explains his concession to the campaigns of the people as follows. So he didn't kill the accused, but instead released somebody and also reduced the punishment to some degree for the others. So his rationale is quoted here. He says, in summary, the people will abandon the person who kills others in the market, and the law is in the hands of the central government. Hence, the judicial officials is unable to subjectively reduce or increase the punishment. When the judge tried the case in the hall and the accused was presented in the court, sorry, it is the white PowerPoint page. So let me continue. So when the judge tried the case in the hall and the accused was presented in the court, the people were shouting outside the gate. There were many captives with decaying bodies, and they were close to death. What power was it that forced more than 100 people to come and treat the arrested thieves as sons? It is indeed an incomprehensible case. Thus your subordinate cannot help but to submit this incomprehensible case for the judgment of my superior, since, as I sentence the 29 people to death and exercise my power with no regard to the fact that the 29 will appeal to the gods, I cannot escape the condemnation of ghosts as I will bring calamity to my offspring. So again, he's quoting the gods. So that the family line from my ancestor will be cut by this office. This is what your subordinate fears. So it is unclear whether or not the belief of heavenly punishment mentioned in his report is Yan Zhenyan's true faith, or merely rhetoric to his disputable decision that might cause his superiors and the policing colleagues. I will maybe conduct another research to see the authenticity of this, this sort of belief of judges by the heavenly interventions. But anyway, this is something really mentioned by the judge himself. Still, the bottom line is that without the shouting laborers crying for justice, would the judge find out the mistakes or corruption of the coastal patrols and release the dying captives before too late? Perhaps he had already found the malpractice of the patrols because they are infamous for this sort of actions. But to avoid the embarrassment to think upon his corrupt colleagues, Judge Yan Zhenyan employed public opinion as his polite criticisms. This could be the case. Anyway, what we have learned from the detailed report of Yan Zhenyan is that crying for justice at court on behalf of your accused relatives and friends may not necessarily offer the mind of the judge. but it was undoubtedly the lawful rights of the people, or even their civic obligation to aid the rightful judgment of the court. So they are entitled to do this. Okay. Now, we just witnessed maybe some sort of effectiveness of the public opinions to help the judge to make his decisions. But if it ever useful for the public to intervene in the courts, this is certainly not the case, because sometimes public opinions could be damaging to the rightful procedure of the court, as we could imagine or maybe realize in nowadays situations. Right, so I call it some sort of double-edged sword of public opinions on the administration of justice. And my example here demonstrating the consideration and also the problems faced by the layman judges. So in another famous case tried by Yan Junyan, homicide case of Guo Qing and others, our judge discovered the injustice of an acting prefect of a subprefecture in northern Guangdong, is Lanzhou, somewhere now is called the Guangzhou Bay by the railway system of China. So when he saw the fierce complaints of relatives of the accused in his viewing section, so he had some reactions to the complaints. After several rounds of review, the regional inspector of Guangdong, who is the supreme judge appointed by the Ming Emperor to supervise the provincial judiciary on his behalf, on the emperor's behalf, disagreed with the original sentence and ordered Judge Yan Junyan to rehear the case. He gave the following comments to Yan related to the role of public opinions on the opening of a court about serious crimes. So the regional inspector says, how can a case of homicide be decided if neither the legal interpretation of the accuser, the defendant's evidence, nor the testimony of the community leaders are considered? So neither of them are considered. In the opinion of the regional inspector, it is almost unlawful to open the court section if the accusation is not supported by the testimony of the local worthies. In other words, if the case is disapproved by the neighborhood at the very beginning of the hearing, it is a strong sign for the judge not to hold a court to answer the problematic complaint. More importantly, if the integrity of the accused is endorsed by public opinion, the penalty imposed on him should not be harsh, so as not to arouse the sentiment of the people. So if the people are supporting the criminal, the judge cannot, do him harshly, doing harm very harshly. Instead, they should reduce the punishment to some lesser degree to pacify the people. So this is some practical consideration of the judge when facing such a problematic situation. So in another case, pondering case of Ao Yue and others, Judge Yan Zhenyan criticized the acting magistrate of Xinhui County, a place adjacent to Macau, who handled the primary court in a mess. When scolding the mishandling of the case, Judge Yan emphasizes the crucial importance of collecting public opinion in the decision-making process. So, quote, I instruct the newly arrived magistrate with the seal, because the acting magistrate has no seal, okay, to collect the public opinion on the related matters and analyze the details of the original situation in order to obtain the correct statements of the two sides, so that the ones found guilty would not experience injustice and the ones released would not escape their deserved punishments. Only then the trustworthy decision, 信誉, can be established. That is to say that only after the opinion of the people is heard, should the decision of the judge be qualified as the trustworthy decision? Xin Yu, I think, is quite, something popular among of the novel writers of traditional China, that to why and how some judgments of the officials could be trustworthy is something need to be considered. And Yan Zhenyan gave us a quality of Xin Yu is consultation of public opinions. So public opinions, however, does not necessarily expose the authenticity behind the crime scene, right? This is something that maybe we are very familiar with from nowadays experience. A good man can commit homicide under unexpected circumstances. And in such situation, even the people cry for the integrity, support the integrity of that good man. The judge should stick to his own gun and continue the trial. By the same token, it is also unlawful to condemn an infamous local bully guilty merely based on the bad opinions of the public. If the judge merely follows the mainstream opinion of the observers at court without solid ground of the law, then all legal technicality would be unnecessary. What's the point of the procedures? And no professionalism of the judiciary would be required or expected. It is just the typical tyranny of the majority. So how to deal with the public opinions is quite something should be quite something thoughtful for the judge, because the public opinions are not always reliable. So how to cope with such situation is maybe the main point of the section I'm going to present to you. It's about the independence of the judge from the influence of public opinions. So having mentioned many aspects of the possibility that the court would be influenced by the public, but how the judge should manage the pressure from the public is something quite crucial for the good practice of the law. Okay, so perhaps if a case were decided simply by the majority role of the observers, the Chinese judge's job would be much easier than the problematic reality faced by Yan Zhenyan, right? So yeah, if it's just the majority role of the jury or maybe of the presented public could decide the case, and the judge is just maybe instrumental to just pass the opinions, but it's not the case of the Chinese judge in the main. Unfortunately, for our main judge, there was no jury system or decision by public role in the layman judiciary, so that the opinion of the observers was just one kind of reference to his decision or measurement of punishment. And it sometimes caused more disputes and difficulties to the judge when the people have strong emotions to the court decision. The primary principle of the judge, indeed, is applying and explaining the statutes and regulations to a case in ways acceptable to the dynastic institution. So he's the servant of the empire instead the servant of the people. He must withhold the institutionally correct application of the law by his professionalism, instead of following public pressure. He is the servant of the empire, as I mentioned, instead of the representative of the local people of his jurisdiction. Therefore, we can see that in the 蒙水斋传 the casebook of Yan Zhenyan, Yan sometimes makes judgments that may forcefully contradict to the public consensus. In Chinese is 离牌中义. This sort of contradiction may reflect the judge's pursuit of justice and insistence on finding out the truth about the case, so that he did not strictly follow the view of the majority during the proceeding. Alternatively, he made his independent decision with or without reference to public opinion or his present situation. Apart from the eyewitness to the crime, the court of traditional China also gave heavy weight to the material evidence, such as the murder weapon. However, we must also consider the situation that limited material evidence could be found. This is sometimes the case faced by the judges, so that the judge had no better resort at the moment of hearing, but rely more on the opinion of the people at court toward the accused. At least they can be the character evidence to the accused. Um, uh, uh, well, by referencing the public opinions to the person. So Yan also tells us that even in the cases that the evidence for convicting a person guilty is truly sufficient, if all the observers had joined together to complain about injustice of the case, the judge should not neglect the people. So this is something maybe sometimes when the effects of the public were really imposed to the court, then he needed to revisit his decision, or even categorize the case to be a dubious one, waiting for further investigation. So even the evidences, the witnesses are sufficient. The public opinion may influence the judge and let him maybe putting the case into the dubious category. So as a dubious case, then it would be more problematic for the follow-up actions, because it need to go through many procedures, many higher level judges to revisit the details and doing all the rehearings, so that it would be a really long procedure when to handle the dubious case. The problem is that I'm not going to having more longer explanation, but the problem faced by the accused in the dubious case is that they would need to be detained in the prison for final decision for that case. Okay, this is one of the problems of the Ming judicial system, and the Qing people and the succeeding dynasty reformed this sort of problem quite radically. But it's another story that I'm not going to present to here. So let's go back to the problem facing by the judge when the people contradicts the evidence of the accused. So on the contrary, if all the neighbors of the accused finger pointing him as guilty, so he's unpopular, everybody accuse him as a guilty person, then even though there is no evidence or reliable eyewitness to the crime, should the judge still accept the accusation and sentence the accused guilty? This is a basic question to be answered by the judge. So everybody tells you that this guy is a bad person. He should be guilty for the crime, but no evidence. Then what to do? The case, okay. The example here I'm presenting on Yan's handling of this sort of case is his boundary case of Liu Yizhi. Judge Yan Zhenyan describes the details of how a judge withheld his principle of independence when he found contradictions between the evidence and the public opinion. The details of the case is that there were reports of banditry in the Guangdong water near Macau. Liu Yizhi and his fellow Feng Yunlu, who died in prison during custody afterwards, had been arrested as bandits by the coastal patrols, who were anxious to hunt for the true outlaws. Yan finds that the accusation is full of doubts, however, as reportedly no action of robbery is seen, no victim of the said crime is found, and no illicit goods and other evidence are collected. So basically, it's groundless to accuse the person, so that the only problem of the accused, as stated by the patrols, is that they stay out and broke the restriction of curfew at night. So it's a minor crime. Maybe it requires a fine. That's it. That's it. But Judge Yan Junyan finds that Liu Yizhi has been very unpopular in his neighborhood, and his relatives and neighbors join together to take the opportunity to accuse him as a bandit. So they want to kill the accused by the state legal apparatus. Okay, Yan exclaims, quote here, the accused is truly deserted by all, so that he must be an unscrupulous person. But accusing him to be responsible to all the recently stolen goods from the locality, without any evidence or witness of the looting, how could the condemned be convinced to give up his appeals? So it's unconvincing, even to the accused person and also to the judge. Moreover, the observers at court had even demanded that the judge should apply judicial torture to Liu Yizhi to force his verdict. So you can tell the private problem between the public and Liu Yizhi here by this sort of demand. Indeed, the judge of the primary court who handled this case before Yan Junyan. So it's not the first hearing. It's at least the second one is the reviewing process. Well, the first judge had insisted that the judiciary could not be abused by the people as the means to avenge the private wrongs of the dodgy person. Judge Yan Junyan endorses this in his review and insists that no death penalty should be sentenced to the accused without new evidence. Afterwards, other officials in the Guangdong Provincial Judiciary who further reviewing the case all echoed with the argument of Judge Yan Junyan. Liu Yizhi had barely avoided the death penalty demanded by the public, but still he faced some lighter punishments by the accusations without solid material evidence, thanks to the pressure of public opinion imposed to the officials. So we can see that although the judges tried to be independent, try their best, but the pressure of the public opinion sometimes could be quite useful to influence the court, at least, making a person accused without evidence to be punished by the lighter penalty. This some sort of how it worked in the public opinion worked in the naming judiciary. As informed by Yan Junyan, we see that some of his colleagues might have accepted the opinions of the mass to conclude their dubious cases, as some judges claim that it is not necessary to examine the details of the crimes committed by the person considered evil by the public. So 以众物为不备查. So it is maybe the attitudes of some of Yan Junyan's colleagues. Although our good judge personally, Yan Junyan personally disagrees with this argument, it is not unacceptable in Yan's time. So it's something shared by many of his colleagues. On the contrary, we also learn from Yan that some judges might be fearful of the pressure of public opinion, so that they dare not to release the prisoners from dubious cases to avoid the sentiment of the locality. Their compromise solution is prolonging the imprisonment of the unpopular suspects till the end of their terms, and letting their successors deal with the case is a very practical solution. Maybe we can understand this mentality. The problem then is not the judges, but the successors. This may create further injustice. However, as many prisoners die before receiving their rightful sentence, Yeah, because sometimes maybe the highest punishment they may enjoy, they may experience is less than death penalty, but they die in the prison. There is some sort of maybe harsher punishment imposed to them, and this is quite unfair, even considered by the contemporaries of Yan Zhongyuan and Yan Zhongyuan himself. So in the pre-modern era, as their forensic science was doubtful even to the judges at that time. When facing dubious cases without eyewitnesses or material evidence, it is understandable that the judge may employ the testimony of the public to serve as the character evidence of the accused to make his decision. But when the case involves human lives, it is irresponsible to make the sentence solely on the people's will. Okay, I think maybe we can agree with that. Yan therefore emphasized that the one assuming the duties of the judge, the only principle I recognize is just the prescription of the law. And thus, he repeatedly pushed forward that the court must be independent to public opinion. Okay, is the principle, or maybe the claim of our respectful judge. So the judge of Canton, the respectful judge of Canton, had best demonstrated his capacity to handle public pressure to ban his judicial rulings in the following serious case of mass murder by poison. 毒月弹压期. So it's the same term of my family, but I'm not because I'm also native of CUHK, so maybe related. But well, this guy is very, very infamous because he used poison. It is almost quite evidence that he killed thousands of people by poisoning a well. Okay, putting poison in the well. So that's why people's sentiment to him and his family is so serious. So as informed by Yan Zhongyuan's report, the judge on one hand resisted the strong public opinions in CUHK that all family members of the accused Tan Yaqi should be put to death. The whole family should be killed because of the crime of Tan Yaqi. On the other hand, Yan Zhongyuan also withstood political pressure from his superiors to pacify because his superior asked him to pacify the angry public by applying harsher penalties to Tan and his family. By referring to the statement of the accused and the evidence of witness reports, Yan Zhongyuan convinced his superior, the provincial surveillance commissioner, who is one of the high authority in the judiciary of the provinces, that certain family members of the criminals were not involved in the crimes, and that it was therefore inappropriate to subject them all to death penalty. So it's fair enough to find out the details, and not everyone in the family should be responsible for the crime. At the end of his report, Yan reaffirmed his stance by declaring that judicial decisions could not be left to public opinion, and the legal apparatus should be kept firmly in the hands of judges of the government. This is the code of Yan. He emphasized that in deciding this case, he has strictly followed the rulings of the codes and regulations. Public opinion is only good for reference in the layman local judiciary, is the stance of Yan Zhongyuan. Therefore, we perceive that by the end of the Ming period, at least some local judges had insisted on the independence of their judicial judgments from the public pressure. They refused to bend the law to punish the accused, hated by all without solid evidence for the accusation. As seen in the struggles of Yan Zhongyuan and his colleagues, should the frontline judges of the provincial judiciary fight for the approval of the empire on behalf of the angry local people to punish the condemned without solid evidence of conviction, yeah, because all death penalties should be approved by the by the emperor at the end? Or should they withhold the legal principles of the state at the risk of arousing the people in their jurisdiction? Yeah, because maybe at the end, if the people too disagree with the judge, they may revolt against the local government. There's some possibility. In the late Ming, at least we learned that after the term of Yan Zhonyan, less than about 2 decades, then the Ming was overthrown by the peasants. So it was not risk-free if you are conducting some concluding your cases without the endorsement of the people. So it seems to be an eternal dilemma faced by the lower level judges of China. So the judges need to be very careful about handling the public opinions. Yan Zhonyan tells us the following idiom he employed to manage this dilemma. Quote, I withhold the balance between human sentiments and the details of crimes, and find my emotion only from the codes and regulations. Unquote. Very tactful here. Perhaps it's not only a tactful way to explain his balance of principles and emotions in managing contradictions between public opinions and the law. Indeed, the best protection of the judge for the possible attacks from all sides is his good knowledge of the law and his integrity in withholding the judicial procedure in the open court. So this is not only tactfully, explaining his situation, but could be very honest, because the law is only protection. So I'm almost finishing, and let's go to the conclusion of today's talk. From the case reports of the Meng Shuizhai Chuandu, we can observe that the perpetual judge of Canton from naming China, Yan Zhonyan, had attempted to withhold the principles of the law in his judgment and refused to condemn the accused simply following the opinion of the mass. More importantly, notwithstanding the pressure of the people's harsh criticism as the sole authority at court, Yan Zhonyan did not persecute his opponents, disagree with his decisions, and he also avoided imposing any punishment on the dissenting observers while allowed to demand for justice in front of him. So they disagree with the judge, but they're unpunished. Okay. Indeed, if he did not follow the opinions of the people, he would explain heartfully the reasons why he did not comply with the public opposition in the case reports. On the one hand, this exposes the layman judge's tactful balance to accommodate public opinions in the legal procedures, as long as the complaints are not breaking the statute of bypassing appropriate jurisdiction, since the observers keeping their different opinions voiced out at the right level of court, they were allowed to express their disagreement to the judge as an agreeable right in the local judiciary. On the other hand, it also reflects that it was impossible for any individual official to dictate the legal proceedings all by himself. As in the open court system, the public could intervene the procedures when they find problems. This practice at least forces the judge to handle the case with extra care, and accordingly, he also needs to explain his decision with solid legal grounds. From the records of Yan Zhonyan, we find that the involvement of public opinion in the judicial process, however, is not always helpful in informing the judge's decisions, nor good for fact-finding and thus improving the administration of justice. This reflects the Chinese idiom on the role of commoners on governance. The water can carry the boat, but it can also overturn it. It's sometimes maybe the situation facing by the judges when public opinions appeared. In his courtroom, if the judge accepted the cry of the public to revisit possible injustice in his case, or follow the observer's opinion to reduce the CUHK's punishment, although he may face the risk of releasing the real bandits. But as the accused in front of him was supported by the majority role of the observers, the judge at least could avoid agitating the sentiment of the locality. So he plays safe by, reducing or releasing the culprit. That is the reason why some naming judges may feel comfortable to follow the public opinions to buy the support of the people by giving them favors. So, the problem of the magistrate is that they are not only judges, but they are also administrators. If they educated the people or maybe offend the people by, not accepting their opinions at court, then he may face some consequence. So to play safe, to smoothen his jobs, there's some tactful ways they may need to consider. Okay, but the people could be hard to please because they were not always happy to see the reduction of punishment, right? Especially when some culprits were seen by them as villains, and they would be unhappy if not seeing the bushets. In this type of cases, the judge must be extra cautious when considering increase the degree of punishment in answering the public opinion of giving no mercy to the convicted. So what to do? However, even though the public opinion was aligned with the judge's own will, he must be very careful in keeping the degree of punishment agreeable with the prescription of the codes and regulations, and never let himself nor the public share the butt of the villain without solid legal grounds. So he must consult the law and make the decision accordingly. Even though the public demand more, the only thing he can give is the utmost prescription of the law. That's it. More importantly, when encountering cases that the judge himself having his own reasonable doubts, he should not follow the opinions of the people to kill their enemy by the legal apparatus of the state. Instead, he must withhold the principle of fairness of the law and ready to bear the criticisms of the people and also his superiors on his releasing or giving lighter punishments to the condemned. In his case book, Judge Yan Zhenyan chooses to prevent applying death penalty to cases without sufficient evidence. While his way may not be able to uphold justice perfectly, it is indeed useful to avoid more miscarriage of justice when absolute truth of the case is unavailable, provided the technological limitations during the Ming period. This is arguably the bottom line motivation that the legislators in ancient China had opened the law court, at least at the lower levels, to invite the inspection of all. Thank you very much. That's the end of my presentation, and I hope you not having the feeling that you waste precious lunchtime to listen such discussions on public opinions, or maybe many things you already know. But I just recap here. I think it may be helpful for us to revisit some of our concepts of Asian Chinese legal system. Thank you very much again for your kind attentions, and thank you, Stephen, and Luz for giving me this precious chance of sharing my opinions. Thank you.
Well, thank you very much, Professor Tam. It was really interesting to hear all you had to say. I mean, we'd spoken just before, and I'd said I was quite surprised by your title because I'd always had this idea that the judges, the magistrates in Imperial China, it was very much a top-down sort of thing. They were very powerful characters. I didn't think they listened very much to public opinion. I thought they just, if there was any influence, I always thought it came from above down, not from
yeah
in the court system. So that was interesting. I suppose you've raised this issue about the public opinion could be useful when there wasn't much evidence, or it was difficult because it could give you an idea what was going on. I think that's probably the origins in medieval England of the jury system, of the idea that you get local people to talk about the guilt or innocence of the accused. But also, as you've raised the issue about the problems of local opinion being too sort of influential over a judge's decision or whatever else. And that sort of raises into some of the questions that we've had. So
Yeah, please.
one question, well, we've had a number of questions, but one question was just this. What was the openness of these proceedings? Who can actually attend the proceedings? You mentioned public opinion, you mentioned people sort of being able to almost shout out during these hearings. So who could attend? Could anyone attend one of these hearings?
Well, a good question. But what I mentioned about the openness is that it's truly open to all. That means, when we look at the court building, the hall of the tribunal, we may see that the judges sit in the middle of the hall, and then he's surrounded by maybe some patrollers or maybe some cops, and then the culprit, the accused, and also the witness or the accuser will be invited to lead or stand. If they have some scholar status, then they can stand or maybe even having a seat if the rank of them or the witness or maybe the accuser is high. But anyway, the center of the hall is for the judge and also for the litigants of the case. And then the public are allowed to stand in front of the court. Then we have a gate, but the gate is transparent, that the people can stand outside or maybe very close to the court to listen to the proceedings, and the judge need to give everything allowed and make the people and let the people listen to all the conversations among them. So it is the type of openness, and nobody was restricted to approach the hall to listen to the proceedings. But the main point is that if they have no point to cry, then they cry, they would be punished by beating. But if they have a point, like there's some 40 details of the statement, then they cry aloud. It's allowed. Okay.
Thank you very much. Well, you mentioned the idea that there were people at times crying for harsher punishments against people. But then you also made that statement that the relatives and friends of the accused also had almost a right to speak out and to ask.
Yeah. Because it's at court, but it's outside the hall, right? Because they are at the gate, so they need not to obey strictly all the etiquette of the proceeding. Okay.
Earlier on, one of the questions that came in before you started to explain it was, do you think that the judges were actually at times frightened of this? But I think you actually raised that in your talk and said that there were times where some judges were definitely influenced by this public opinion because
yeah. And an interesting point of the case book I frequently quote today is that the psychological reaction of the judges is mentioned, is depicted by the judge himself. So it's quite interesting to learn about the counterpart or the other side of the story, because sometimes why we may think that public opinions is not important in the Chinese traditional proceedings is that at the end, the judge, of course, would not say he's influenced by the public, but the effect is well reflected by their own reports or maybe their own explanations. Okay.
Sort of building on from that, one of the questions here is about, do you know how typical the approach and practice of Judge Yan was? Because Judge Yan obviously did comment and say it does influence judges or it could influence judges. Do you think his approach was typical? of judges at the time?
Well, the maybe the merits of the casebook is that he didn't only mention himself. He also mentioned the reactions or also the comments of his superiors and colleagues. And he's not very typical because he tried to emphasize that uh, some of his ways are different from his colleagues. Like he didn't like his colleagues strictly follow the opinions of the people and do the decision to please them, to please the public. But instead, he withhold some principles of the law. But his way is seemingly more acceptable from the superior. So he well, one of the points of publishing his casebook is he wanted to be promoted to some higher level. So he demonstrates sort of good practice of judgment. Okay, but so it is the good way of judgment, but maybe not the typical way. But to be a good way, that means if people or other judges could follow this way, they would be, appreciated.
The Ming judges were a bit like modern academics. Then publication was a way to sort of thing. But
Yeah, sure.
again, there's a question that came in about, is there any evidence that the accused and his supporters or the public put pressure on judges strategically to influence the outcome?
Oh yes, of course. That's why this is one of the arguments of Yan Zhongyuan that he may see the rich people. They may organize. They have the ample resources to organize some people together to try for their benefits, for their maybe to be the witness of their good character. So it is not impossible for the rich people. Now, they may be local bullies, they may be disliked by many others, but they organize some of their followers to act in front of the gate of the court. It is possible. So that's one of the arguments that Yan Zhongyuan should not, or the judges should not strictly follow the opinions appear in front of him. They may be abandoned or they may be highly distorted because of some intentions behind the organization of such crowds.
Thank you. And then a follow on from that. So there's evidence that there was a lot of sort of pressure on the judges from the public opinion. Were any judges actually physically assaulted? Is there any evidence of this, that there was actually, physical threats or physical assaults on judges at this period?
Well, I cannot see hard evidence on this type of, threatening physically the judges, but it is quite possible if the judge is not maybe following the majority opinion of the locality, he may find difficulties in leaving the tribunal. There's some saying of it, but it's not recorded in the case books and also from the history records I encountered. Yeah, but maybe in the novels or maybe in some private BG, the miscellaneous records of the intellectuals. This sort of things happen, but not very frequently.
I think in one of your quotes, you referred to the fact that the judge was concerned about their own safety and the safety of their families as well. So
yeah, but the safety, the punishment, or maybe the safety is not threatened by human beings. It's by some supernatural forces. So that's another thing. There's an interesting argument here.
To worry about the gods.
Yeah.
Also, sort of following on again from the idea of how much there was public opinion was expressed to the courts. Was the public invited to actually help the judge to collect evidence, to sort of support the whole sort of criminal justice process rather than just supporting a particular party's interests?
Yeah, it's really a good question. But the public opinion, or maybe the consultation on local opinions mainly happen in the pre-court sections, that the judge is gathering the evidence, or maybe deciding whether or not uh, he may accept the complaint and open the court. The problem, or maybe the special characteristic of the Chinese traditional prosecutor. Yeah, because when he accepted the complaint, he need to clarify whether or not the complaint could be could be rightful for the accusation. Then he need to find evidence, like consulting the local average, to decide if the complaint can be established. If he decided that it could be established, then he opened the court. That means he agree with the facts, or agree with the accusation. So it's the basic procedure that he need to consult the opinions of the public first. But during the proceedings, the formal proceedings, then the public opinion should not be consulted as one of the one side of the witness. Okay, that's maybe the way that the public opinions could influence the judge in the pre-sections, not in the formal procedure.
Thank you very much.
Thank
And
you.
again, taking you back to sort of very early on, you mentioned something about a case report being published within 3 days.
Oh, yeah.
I mean, was this a common factor? Was there such a fast publication of?
Well, I indeed used to have some struggles to see if it is the special practice of the engineer, or is common practice of the Ming judiciary. But I find that from other places, like in Guizhou, in the Jiangnan area of China, similar practice happened. So the issue is not whether or not the case reports would be published, but for how long, or to wait how long for the after the court section, should the judge publish it. Yan's pronunciation here is that it's fast if doing it within 3 days, but his colleagues in other places may be slow, that says maybe a week or 10 days. That should be acceptable. But at the end, the case reports must be seen by the public. Anyway, yeah, it is the common practice.
Thank you. And the follow on to that is, how were they published?
Oh, not all the judges publish the case reports in book form. Sometimes it's only the judges who are so confident to their decisions that they dare to give the reports into a book form to circulate among the people, and to circulate in other places of the country. But they are required to post to do the poster in front of the gate of the yamen, the tribunal. That is the common practice, or the legal required way to publicize the decision. And they, at the end, all the related materials of the case, including the case report, the statements of the accused, should be submitted to the higher court for review. So it's the other way of the circulation. Yeah.
Yeah, I think that's it. This idea that you say there about, literally a publication outside the Yemen, outside the court, just saying this is what's happened. And then, you get then an idea of probably a much more sort of public process than we saw in other areas of the world at that particular time.
Yeah. I think it's quite common in the modern world.
Okay. Yeah. Well, and then a follow on again. Were there any consequences for members of the public when they made false accusations or falsely tried to speak up for the accused? Is there any evidence that any follow-ups came up if the public did speak up and were trying to sort of wrongly influence the court?
Well, if somebody, giving false statement to support a certain litigant, then can we still consider that person the public? They may be a member now, then included in the case. So if it is considered, or if their opinions is really considered, then they are they would become one of the litigants, and so they should also bear the responsibility of being, the party of the accuser or the accused. If they are making false statements without grounds, or maybe they telling lies, they will be punished according to the law, the code on false accusation or false statement. The normal degree of punishment for such false accusation or false statement would be 3 degrees higher than the prescribed punishment for the accused. So it's quite a consequence. So people need to maybe consider if their statements are rigid or false. Okay.
So this was all covered in the code, but for the public opinion, I think you've sort of painted for us today an image of a court that I never really thought. I've now got this idea that there were people inside and outside the court sort of shouting out at times and whatever else. Whereas, of course, I suppose, again, I always thought of a very sort of top-down judicial process with the judges with so much power that there was just complete respect and quiet really to listen to the judges more than anything else. So it's a really fascinating idea, the whole lot.
So if we were people in traditional China, maybe we would go to the court to see what happened for entertainment. Yeah, sometimes if it is safe, if others already cry out for something, then you just follow or maybe reinforce that voice. It will be fun. and quite safe if the judge is not punishing the first voicer.
Yeah. They wouldn't be crying out for contempt or anything else. They were willing to listen.
Hopefully.
Thank you very much. I think we've had to come to the end of our talk today. So thank you very much, Kochai. Thank you.
And hope to see you again. Thank you for your kind attention.